I'll call this meeting to order. Welcome to meeting number 5 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the motion adopted on Tuesday, February 8th, the committee is meeting on the review of the Protection of Communities and Exploited Persons Act. Today's meeting is taking place in hybrid format pursuant to House Order of November 25th, 2021. Members are attending in person in the room and are remotely using the Zoom application. The proceedings will be made available via the House of Commons website. I think everyone knows the mask policy, I think, still. And so just if you're not speaking, try to have your mask on. I think members are okay to, they're distant seat apart, but staff, if we can ensure that we have them on unless you're drinking or eating, that would be great. I'd like to welcome our witnesses. We have Gwendolyn Allison from Barton Taney Law, and we have Paul Brandt, public figure. We have from the Pivot Legal Society, Carrie Port. I think we're just going to make sure she gets some technical help before she comes on. And Lindsay Watson, Legal Director of Pivot Legal Society. Chair? Pivot will have 5 minutes, but before that, I'll ask...
Chair?
Yes.
Sorry, I don't think the earpieces are working. Are we all getting volumes or no?
I know I can't hear you.
Have you got your volume up on it? Yeah. Randall's good. You guys good with the audio? We're good? Test, 1, 2, 3. Yeah, you're good? Okay. Okay, so each of you, the witnesses, so the two individuals and Pivot Legal Society, each will have 5 minutes each. So I will start by Gwendolyn Allison of Barton Taney Law for 5 minutes, and then at the end you'll have questions and there'll be rounds of questions. So over to you.
Thank you to the committee for the opportunity to appear before you today. I'm a lawyer with 26 years of experience in employment and human rights law. I have a number of clients who've appeared before you or are appearing before you, and I've been co-counsel in both the Bedford and Barton decisions. Although I'm aware of the recent Ontario Court of Appeal decision upholding some of the laws, my introduction today will focus on the implications for employment-related laws should Parliament decide to repeal PASEPA. I'm mindful of the comments I've seen in both the briefs and in meetings that decriminalisation will endow those in prostitution with labour and employment rights and access to courts and tribunals. In considering how those laws may protect the safety and security of those in prostitution, I'll make a few introductory comments. First, prostitution is highly gendered. The vast majority of buyers are the men and the vast majority of providers are women and girls. There are some boys and men who provide commercial sexual services, but the buyers are still men. 2, prostitution targets the vulnerable. In the Bedford case at paragraph 86, the Supreme Court of Canada recognised that many of those in prostitution are not exercising a meaningful choice to engage in prostitution, but rather have no meaningful choice but to engage in prostitution. 3, prostitution has a hierarchy that is both classist and racist. The poorest, the racialised and the most vulnerable are at the bottom. Not only that, but prostitution encourages racism as buyers seek out experiences linked to racist stereotypes. The courts have recognised that prostitution is inherently dangerous. Women in prostitution are subjected to male violence at very high rates. And as the Supreme Court of Canada has recognised, the source of the harm is the men who buy and those who profit from prostitution. I recognise that many employment-related laws are mainly within the provincial sphere of regulation and out with the control of Parliament. So if Parliament decides to repeal, your role becomes very limited. Labour and employment laws will not protect those in prostitution. Those laws are targeted to the protection of employees, and it's widely recognised that in every legal regime, regardless of whether it's described as legalised, regulated or decriminalised, and regardless of the setting, whether it be street level, private homes, massage parlours, managed brothels or escort agencies, those engaged in prostitution are classified as independent contractors. That is the case in the bunny ranches in Nevada, the mega brothels in Germany, the windows in Amsterdam and in New Zealand. While in Canada, that would permit those in prostitution to register for EI and CPP, it would mean no minimum wage, no overtime, no scheduled time away from work, no vacation pay, no paid sick leave, no bereavement leave, no severance pay, no benefits, no job security. And as independent business people, those in prostitution would be responsible for remitting income tax and, depending on their earnings, collecting and remitting GST. The mechanisms for labour and employment law enforcement would not be available to those in prostitution. And that lack of protection has been recognised in recent studies in New Zealand and Australia. And even those studies that support decriminalisation acknowledge that neither decriminalisation nor legalisation have had any substantive connection to improved labour rights. Similarly, human rights legislation is inadequate. Although employment is more broadly interpreted than under the common law, the key requirement is that there has to be an employer, someone against whom the women may seek a remedy. Human rights legislation could at most only operate to protect women in indoor managed situations. And decriminalisation of the buyers and profiteers has implications that go beyond those in prostitution. Over many years, and it has taken many years, it has become unlawful to require a person to engage in sex as a condition of their employment. So the question arises as to how, in a decriminalised environment, could those unlawful activities become lawful? A final strand of protection is provincial workers' legislation to ensure safety in the workplace and compensation for work-related injuries. That would require significant amendments to legal regimes over which you have no control. What would occupational health and safety regulations look like for the prostitution industry? How would we eliminate the risk of violence? How many sexual acts can a woman endure during any shift? How many hours should be worked? How much topical anaesthetic should be used? All of those issues are under research in Canada and are not covered by current regulations. Arguably, one benefit of the scheme is the ability to obtain compensation for workplace injuries. Such a scheme could, but does not yet, compensate for the known injuries caused by prostitution: violence, mental disorders, occupational diseases, repetitive strain type injuries, and pregnancy. The scheme, however, is also employer funded. So the practical issue is in compliance. Who pays? Again, there has to be an identifiable employer. Otherwise, the independent contractor would be the one to have to register. Without being registered, there is no protection. My submission, the lack of attention to those in prostitution and the obvious inapplicability of the current mechanisms illustrate how ineffective employment-related legal regimes are to protect the safety and security of those in prostitution. Thank you. I'll be happy to answer any questions that you may have.
Thank you, Ms. Allison. Next, we'll go to Paul Brandt.
Thank you, Mr. Chair. Today, I'm pleased to present to you and this standing committee for your deliberation on the review of the Protection of Communities and Exploited Persons Act, or the PCEPA. Thank you for your invitation. I'll be speaking in support of the PCEPA. I'm here today as a private citizen, the father of 2 children, and as someone who has had the great privilege of speaking with many women and children directly impacted by human trafficking and the sex industry. Aside from my 25 years in the music industry and 2 years as a pediatric registered nurse prior to that, you may be interested to know that I'm the founder of an organization called Not in My City, formed to disrupt human trafficking. I've also recently completed my time as chair of the Government of Alberta's Human Trafficking Task Force. It's my hope that the knowledge I've gained over the past 18 years of being involved with working on behalf of communities and exploited persons will prove useful to you as you review and make decisions on how best to move Canada forward and to end the sexual exploitation of women, children, and youth. 15 years ago, I saw a glimpse of a horrific future for women, children, and youth in a country using the decriminalization model. I was in an area internationally renowned for the trafficking of young children. It was rife with organized crime. On that street was a warehouse where children were given drugs or downers to force them to sleep during the day. They were then given amphetamines or uppers at night to wake them up before being taken by their traffickers, pimps, and bodyguards to body rub parlors and brothels where they were forced to sexually service men. Across the street, a 3-story building was under construction, which was being financed by a California-based businessman to be used as a sex destination hotel to service busloads and plane loads of men from around the world who pay to rape and sexually assault young children. Children whose tiny bodies had been used up and had died were being buried in the yard behind the construction site. Those who had survived were sold to sex buyers until they aged out, were impregnated by their abusers, or had HIV/AIDS. These children no longer had any monetary value to their traffickers. It was one of the most horrific places I've ever been. I met a little girl that day on that street who was 5 years old and was being sold six to 8 times per night to adult men for the purposes of sex. Since arriving back in Canada from that trip until current day, I've immersed myself learning how there are connections between prostitution, trafficking, and the growing commercial sex industry, how sexualized violence thrust upon children creates a progression of subsequent abuse and victimization, often resulting in them being trafficked. How traffickers use popular online platforms to lure and exploit victims who are often children. The two most common sites to facilitate human trafficking in Alberta are Snapchat and Instagram. How 75% of those in the sex industry were first exploited as children. How over 50% of trafficking victims in Canada are Indigenous, despite only representing 4% of Canada's population. How new data released May 2nd, 2021 by Statistics Canada reveals that a record high number of human trafficking incidences were reported to police in Canada in 2019. Reports are up 44% from the previous year, and more than 1 in 5 victims are 17 or younger. Crime investigators I spoke with detailed how child abuse sexual material created to feed the demand in the sex industry that they had to view during investigations had become their nightmares. One former RCMP officer detailed that the worst part wasn't the visuals, but the sounds the children made while being sexually tortured that he couldn't get out of his head. While not to be conflated with the activities of those who willingly enter and stay in the sex industry and human trafficking are related. Many women with former experience in the sex industry have told me that while they were in the life, they would have inaccurately said that they had chosen to be involved in the sex industry. It was only upon exiting and beginning the journey to freedom that they were able to realize that they'd been victims of force, fraud, and coercion during their time in the sex industry. They had only said they were willing participants because of their traumatization and in a desperate attempt to regain some sense of control. PSEPA is effective when enforced, yet more can be done to ensure that it's enhanced and utilized effectively and uniformly across the country. Removing or altering the PSEPA by introducing decriminalization or legalization will negatively impact women, children, youth, and Indigenous populations in Canada. The evidence is clear. Since its introduction, more victims are being identified and supported, more children are being protected, and more sex purchasers are being charged because of the urgently needed framework and safety mechanisms created by the PSEPA. Thank you.
Thank you, Mr. Brandt. Next, I'm going to see, have we got the witness? Yep.
Hopefully, can you hear me all right?
Okay, I think both of you, if yours doesn't work, we can have Ms. Watson, but over to you, Ms. Port.
Thank you. Good afternoon, and thank you for having us here today. Pivot Legal Society works in partnership with communities affected by poverty and social exclusion across Vancouver, BC, and Canada to identify priorities and develop solutions to complex human rights issues. Our work engages all levels of government, including federal laws and policies. Pivot's work includes challenging laws and policies that force people to the margins of society and keep them there. The last time I testified before a government committee on behalf of Pivot was in September of 2014, when PSEPA was in its study phase. At that time, Senator Donald Plett said to me, and I quote, "Of course, we don't want to make life safe for prostitutes. We want to do away with prostitution. That's the intent of this bill." My first point is that the purposes of PSEPA, as expressed in its preamble, are contradictory. Laws that are intended to stop sex work from happening cannot help but put sex workers in harm's way. We have several recommendations to make to this committee. At the heart of all our recommendations is the necessity of centering the lived experiences of people who do sex work and experience the realities of criminalization. 1, don't conflate trafficking and sex work. Sex work, which we define as the consensual exchange of money or goods for sexual services, is not trafficking. And trafficking laws should not be used as a reason to investigate sex workers and sex work businesses. 2, repeal the laws that criminalize adult sex work. We recommend repealing all criminal laws that prohibit the purchase or sale of sexual services by adults and that limits adults selling sex from working with others in non-coercive situations. This includes the PSEPA and provisions such as Section 213 Sub 1 A and B, which were not constitutionally challenged in Bedford. We also recommend that you remove the immigration and refugee protection regulations that prohibit migrants from working in the sex industry. 3, create appropriate provincial laws and municipal bylaws in consultation with sex workers. Decriminalizing sex work would not necessarily mean that there are no restrictions on sex work. However, the boundaries on sex work should be developed with sex workers, who are the true authorities in their lives and work. 4, recognize the complex realities of Indigenous peoples who sell and trade sex. Narratives about Indigenous people and sex work tend to focus on their overrepresentation. Indigenous sex workers Pivot has worked with say this is due to their lack of economic opportunities and the fact that sex work is an occupation that does not require formal training. Indigenous people across Canada also have a great diversity of experiences and may use sex work as a way of resisting the colonization of their communities, perpetuated through displacement from lands and the repercussions of the genocidal residential school system. Provincial systems for youth and care, also disproportionately Indigenous, often do not meet their needs. As a result, Indigenous youth often struggle to support themselves when they try to escape abusive circumstances. The federal government should increase broad-based supports. This would position Indigenous people to decide whether they want to participate in the sex industry, and if so, under what conditions. 5, learn from other jurisdictions. New Zealand provides a model for decriminalization of sex work that was developed in consultation with sex workers and that respects and promotes their human rights and safety. Over the past decade, research has suggested that this legal regime has resulted in sex workers having greatly enhanced control over the conditions of their work, including their ability to refuse clients and to insist on condom use. And finally, 6, work on undoing the stigma that surrounds sex work. The greatest commonality between sex workers in Canada is the stigma they face. Most sex workers live in fear that their work will be revealed to family and neighbors. This stigma perpetuates over-policing and supports conditions that have allowed predators to murder, sexually assault, rape, and abuse sex workers with impunity. Education is also needed to dismantle negative stereotypes about sex workers, but law reform is essential. Changing the law would be a first step towards undoing the stigma and accepting sex work as an occupation and people who do sex work as full members of our communities. Thank you.
Ms. Port, I'd now start our first round of questions. Before I begin, I want to welcome Mr. Fortin back to the committee. Hopefully, we'd like to see you back as always. Your health is good. And also want to welcome Mr. Cooper, our new member of the committee. So thank you, Mr. Cooper, for joining us. Over to you, Mr. Moore, for 6 minutes.
Okay, thank you, Mr. Chair, and thank you to all of our witnesses for appearing on what is a really important study. The Protection of Communities and Exploited Persons Act. I was pleased to be part of a government that brought in that legislation that criminalized those who fuel and perpetuate the demand for prostitution by purchasing sexual services and protecting those who sell their own sexual services. Dealing with the most vulnerable in our society and making sure that the law is responsive to court decisions, but also we're doing our best to protect those that are vulnerable. I want to ask a question to Paul Brandt. Thank you for appearing today. I know this is something that you certainly don't have to do in your time, but you spoke with great passion about what you saw in other countries, and we heard from previous witnesses that complete decriminalization of prostitution in Canada could lead us to becoming the brothel of the United States. And it was really horrific to hear the description you gave about a country where this has been completely decriminalized. So I'm wondering if you could speak a bit more to that, as well as Not in My City, combating human trafficking. Interested to hear a bit more about that. I know there's a perception about human trafficking as being a big city issue, but I'm from New Brunswick, and I know in some of our smaller Atlantic communities, human trafficking and the corridors that people are trafficked, this is something that's happening right now across Canada. So if you could speak to that, I'd appreciate it.
Yeah, thank you so much for the question. Not in My City as an organization I founded about 5 years ago here in Calgary, where I am right now. And the idea behind this organization was to raise awareness about the issue of human trafficking and to disrupt human trafficking and sexual exploitation, especially as they relate to children. And you're right, looking at places around the world where we've seen legalization and decriminalization, like Norway, Amsterdam, Germany, where I was there in Cambodia. These are examples where the failed experiment of legalization and decriminalization occurred. We see brothels, drive-through sex boxes at truck stops where buyers pull into walled stalls to buy women by the hour. Clubs with small flat rate will buy unlimited sex with as many women as a man wants during his stay. 5 years ago, when we started Not in My City, it came to my attention that it's well known within the anti-trafficking community that one common menu item available to sex buyers occurs once a year during the time period of the Calgary Stampede. There's a high demand by local and international sex buyers who visit the city at that time for specifically Indigenous women and girls to facilitate their sexual fantasies. And undercover investigations here in Alberta have turned up online communications on the dark web between traffickers. They say we don't deliver to Calgary, but we can get it across the border. And the it that they're referring to are trafficking victims forced into the sex industry to meet demand. I would say that my home province of Alberta has made great strides in the past 5 years by uniformly and consistently applying the tenets of the PSEPA, and the momentum is changing communities for the better. We're seeing a lot of cooperation, and recently Not in My City has introduced a position called the Safety Network Coordinator position through the Alberta Law Enforcement Response Team, ALERT, who handles crimes of this nature and organized crime. This Safety Network Coordinator is assisting those wanting to exit the sex industry, introduced through the Alberta Law Enforcement Response Team, to be there to effectively and efficiently intervene. And I'll finish with this, and this was really telling to me. I was speaking with Staff Sergeant Colleen Bowers the other day with Alberta Law Enforcement Response Teams. She's heading up the Southern Alberta Human Trafficking Counter-Exploitation Unit. And this is her quote: "The Nordic model approach of the PSEPA is the most effective middle ground for addressing the connections between human trafficking and prostitution. Uniform application of the PSEPA, along with increased public education about the links between human trafficking and the commercial sex industry, are improvements I would like to see to enhance safety within the community. ALERT's client-centered approach, recently implemented in Alberta through the Safety Network Coordinator position, has been a great success in assisting those involved in the sex industry who would like to exit, are being trafficked, or at risk of being trafficked. The SNC's success at intervening on behalf of those in the sex industry who need immediate support depends on the protections available within the PSEPA. The activities of the SNC were developed with the PSEPA in mind. The repeal of the PSEPA would be disastrous to both willing and non-willing individuals who are involved in the commercial sex industry. The risks are simply too high. The international evidence of failures of decriminalization and legalization is clear. Law enforcement jurisdictions across Canada do not have the capacity to address the amount of organized crime and victimization that is likely to occur should the PSEPA be substantively altered."
I'm seeing I only have 30 seconds left, but I do have one quick follow-up. You mentioned PSEPA is effective when enforced, and you mentioned the Alberta experience. I know you're an Albertan, but we have heard of other provinces where it's not being as effectively enforced. Can you speak quickly to that?
Quick answer, please.
Yeah, I would say misapplication of the Act causes harm. It has to be applied the way that it was intended and the way that it was written, and where it's uniformly and consistently applied, we're seeing that it's working. It's gaining incredible ground here in Alberta right now and in the work that we're doing across the country.
Thank you. Thank you, Mr. Moore. Now over to you, Ms. Briard, for 6 minutes.
Merci, Monsieur le Président.
Thank you very much, Mr. Chairperson. Mr. Brandt, I'll continue in the same vein as our colleague, Mr. Moore. What would your recommendations be? What should we be aiming for in this committee with the study that we are currently seized with?
Thank you for the question. I would say that supporting and maintaining the PSEPA and enhancing the legislation as it is would be valuable for Canadians. Women, girls, youth, and children, and a disproportionate amount of Indigenous people are lured into the sex industry, and the PSEPA addresses this issue. By enhancing measures within the Act, the PSEPA can be made more effective. In the brief that I submitted to the committee, I outlined a number of steps that I would recommend. Number one, I would say more focus on prevention within the Act. And, I've heard in previous testimony that you can't legislate prevention, but we're actually seeing the exact opposite when happening in the work that we're doing here in Alberta. When the Act is applied as it was intended, we see prevention actually being one of the main mechanisms that's triggered. The second, I would say, is that resources and additions should be made available within the Act for re-education and vocational opportunities for survivors. My friend, Ms. Tricia Baptiste, who has also testified before this committee, talks about how for her it was not a choice, it was the lack of choice. And we're really seeing in this client-centered approach that we're taking here in Alberta that it is all about choice. Additions to the Act to enhance access to addiction and trauma resources, I believe, are key. Strengthening the Act to encourage and support the PSEPA as a bridge between all levels of government, including municipal, provincial, and federal levels. We're just starting to get to a place now here in Alberta where we're starting to see those connections happen through a newly formed community response model and the creation of coalitions across the entire province, where all levels of government are being engaged in working together. Requirements and provisions of resources within the Act to ensure the use of shared definitions in relation to trafficking. This is extremely important. Consistent approach and training, universal branding and public messaging, and universal and consistent ongoing training, I believe, are key. And finally, I would say, although it's not available because it has not been released by the government of Alberta yet, the study that has been turned into the Alberta government by the Alberta Human Trafficking Task Force recently, I would suggest that looking at suggestions within that report on trauma-informed, most promising practice detail, I would suggest that you contact the government of Alberta to review the report called The Reading Stone. I think that this committee might find some of the suggestions within that report very helpful.
Merci.
Thank you very much. I'll now ask a question of Ms. Allison, if I may. Ms. Allison, you were involved as a lawyer for the coalition in the Bedford case, so you're aware of the findings. The court found that the provisions of the criminal code in effect at the time breached the right to safety of the individuals who sold sexual services. Since C-36 came into force, do you believe that those working in the sex industry are better supported? And what would your recommendations be also, please?
Thank you for that question. One of the challenges, and I think Mr. Brandt has touched on this, is that C-36 or PSEPA is not being uniformly enforced across Canada, particularly in BC. It was declared very early on that the Vancouver Police Department would not engage in arresting purchasers of commercialized sexual services, and that policy has been taken throughout BC in other police forces. So that's the first problem, is that the legislation has not been given a chance to operate properly in BC. I do think that there are a number of improvements to PSEPA that could be made to make it, to protect the rights of women and those engaged in prostitution. And I'll say that there's a big difference between PSEPA and the previous legislation. The purposes are completely different. They're in different sections of the criminal code. It's now a crime of violence rather than a property offence and a nuisance offence. So it recognises that this is a crime of violence, as the Ontario Court of Appeal has just recognised. I would say a couple of ways that we can improve the federal approach towards prostitution. First of all, we need consistent application across Canada. Second, when I appeared before Parliament back in 2013, I think everyone was unanimous in saying that Section 213 should be repealed. and I agree with that still, is that the communication provision outside schools and churches, although I recognize and appreciate the goal of it, it has the effect of criminalizing those who are engaged in prostitution. And also by criminalizing them, it prevents them from exiting. So in my submission, that should be repealed. Second, expunging the records of those who've been convicted of selling sexual services in order to permit them to gain employment. There are many pieces of legislation across Canada that prevent those with criminal records from working in particularly the volunteer sector. And so that is a barrier to exiting, which tends to punish the more vulnerable.
Thank you.
Increased funding.
Sorry, Ms. Allison, we're out of time. I have to go to the next witness. Hopefully we'll catch up on that next. Next, for Mr. Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson. Well, first of all, welcome to all the witnesses. Thank you for being here today. This is a scourge, this trafficking in persons. And I was affected when I listened to Mr. Brandt about what has been done to children and what is being done. I can't fathom that this is actually occurring in Canada nowadays. And yet this is part of our job to try and see past this and through this and to bring improvement and enhancements. Now, Ms. Allison, if you could continue with the response that you were giving when you were cut off just now as to your suggestions. You talked about uniformisation. I was surprised in your testimony that in BC, the provisions of C36 aren't consistently applied, and what you have recommended is that there be a uniform enforcement across Canada. You talked about criminal records that need to be expunged because otherwise they prevent offenders from working. I'd like you to continue with that list of things that can be used to improve the situation.
Thank you for the question. I only have a few more. One is the increased funding for exiting prostitution. We know from experience in countries like Sweden that it takes a consistent investment in the exiting programs. And the fourth one was to commit to a long-term education plan. When the model of end demand laws were introduced in Sweden, they were highly unpopular, and the government committed to an education program that led to, within a few short years, a complete reversal of that. And now the laws in Sweden are actually very important and very popular amongst the people, and they've been accepted by them. So a recognition and an understanding of what the law actually means. I've certainly had discussions with law enforcement and lawyers in BC who haven't really appreciated what the law actually says, and they have a mistaken impression of what is involved in the law. So we need a consistent long-term education plan in order to assist that. Thank you.
Merci, Madame Allison.
Thank you, Ms. Allison. Since the coming into force of C36 in 2014, out in the field, and I'll have the same question for Mr. Brandt, who can respond after you, out in the field, how would you describe the difference between the period before C36, i.e. 2014 and prior, and that period after 2014, i.e. 2015 going forward?
So in my experience in BC, I advise groups who advise frontline workers, and the ones they're telling me is that, well, since the law hasn't been applied at all in any great sense, there's nothing really that's changed from before or after.
Thank you. Merci. Et Monsieur Brandt, s'il vous plaît.
Mr. Brandt, if I may, I'd like your opinion on the same question, the difference out on the ground pre and post the coming into force of C36.
Thank you for the question. I would say that we're just starting to see, like I said, in jurisdictions where it is being applied uniformly, a shift and a change. But it is taken this long to start to see the cooperation that is needed to see positive results. I would say that the fact that this committee is meeting and that it's already been revealed through the process that there are incredibly diverse opinions and approaches to the issue of the sex industry, right down to the words that are used to describe it, that it's proof that PSEPA is working. This too is too important an issue to allow only one view to be upheld. We must look at the lived experience of all who are impacted by the sex industry. When the Supreme Court of Canada decision itself acknowledged that there's inherent risk in the sale of sexual services, that was key. There are risks inherent whenever a person is prostituted by others or is of their own accord prostituting themselves. And in the Swedish law that the PSEPA was fashioned after, it's written into the legislation that prostitution by its very nature is discriminatory against women. The way that we apply that here in Canada is the quote in the PSEPA that people who are providing their own sexual services are not criminalized, rather they're viewed as needing support and assistance, not blame and punishment. And in practice, we're starting to see an understanding that is developing with frontline agencies, with law enforcement, and with the public to start to understand these very subtle and nuanced ways to look at this issue. And I believe that that's as a result of the framework that was created by the PSEPA.
Votre expérience, il doit pas me
I'm sure I'm about to run out of time. I have about a minute left. Very quickly, Mr. Brandt, if you would. Aside from criminal fines or penalties such as imprisonment, based on your experience out in the field, what could convince a perpetrator to cease and desist in the procurement of or buying children? I can't believe those words are coming out of my mouth, but doing things of that nature, how can we prevent them from acting in this way, aside from penalties of that nature?
Thank you for the question. I would say that aside from crimes or from penalties to the crimes of this nature, there's a question that I asked a group of young men, hockey players here in Alberta, just this past Friday night, and talking to them about this issue. They were 17 years old to 20 years old, young men just about to sort of enter adulthood and enter the world.
Quickly,
and
Mr.
they have
Brandt,
influence
sorry.
because they're hockey players and people look up to them. Thank you. I would say, what if the people of this committee, or I asked these boys, what if they and the people of Canada determined to change culture and industry of exploitation so that by the time that young people of today grow up, they no longer live in a society where men are emboldened to purchase another human for their own gratification. This requires a cultural shift, and the PSEPA creates a framework for that cultural shift.
Brent, thank you, Mr. Fortet. Over to you, Mr. Garrison, for 6 minutes.
Thank you very much, Mr. Chair, and thank you for the witnesses for being here today. And I want to say a special thanks to Pivot Legal Society, because I think it's very important that we center the voices of those involved in sex work and those who work directly with them instead of talking about them. And so in your introduction, Ms. Port, talked about the danger of conflating sex work and trafficking. And we've heard that from other witnesses here, that if you conflate the two, that you miss the real trafficking. Could you expand a bit on why that's one of your key points?
Well, thank you for the question. I think when we're constantly conflating sex work and trafficking, and I can say that many of the witnesses who have appeared before the committee have definitely been doing that, when you say that all sex work is trafficking, you miss out on actual violence and exploitation that happens in the sex industry that does not rise to the level of trafficking. That's part of working conditions, negative working conditions that are caused by criminalization. Criminalization really forces the sex industry into dark shadows, into the underground, and it really facilitates the violence and exploitation that happens. So calling them the one and the same thing is really does a disservice to both sex workers and the work that they do, and to trafficking victims.
Thank you very much. You in that response, mentioned forcing sex work into marginal places, both physically and in the community. And I know we've heard from other witnesses that this is what makes this law more dangerous for sex workers. Can you talk a bit more about how that works, the criminalizing the purchase of sex? How does that make sex work more dangerous?
Sure. Well, if you think about it, the prohibitions on communication and advertising make it very difficult for sex workers to properly communicate the terms of transactions and consent with their clients. So, for sex workers working on the street, their clients are wanting them to get into the car with them very quickly because they don't want to be detected by law enforcement for the crime of purchasing sex. And so rather than having time outside of the vehicle to assess the client, to assess whether there are any weapons in the car or items of restraint, to perhaps consult a bad date sheet, the sex worker is asked to get into the car quite quickly. And once she's behind the closed door of a moving vehicle, she's lost the power of negotiation. And for sex workers who are advertising online, they're no longer able to place very explicit ads. Clients are, unwilling to engage with typical screening practices, which include giving a real name and a real phone number. And so they're finding it very difficult to assess the safety of potential clients prior to meeting them in person. And that is when misunderstandings can happen and potential violence can happen.
And we've heard today several people asserting that the PSEPA law is not being enforced in British Columbia. Would you say that's the experience of sex workers that you work with in British Columbia?
Well, there's a couple of things. There's provincial sex work enforcement guidelines that were adopted, I think, in 2017 by the BC Association of Chiefs of Police. And those are basically guidelines for police interactions with sex workers that prioritize sex workers' safety, dignity, and respect over other considerations. I know that the Vancouver Police Department doesn't enforce sex work laws between consenting adults, but they do focus on issues such as the exploitation of children, sexual exploitation of children and youth, and human trafficking. And what we hear from sex workers themselves is that they continue to be surveilled and harassed by police while they're working on the street. We've heard of police parking marked police vehicles on strolls where sex workers are working, or stopping them for street stops or for other reasons while they're trying to work. And so they continue to be harassed by police. So whether or not the police are actually enforcing PSEPA, they continue to survey and harass sex workers.
And would you say that if we were to recommend repeal of PSEPA, that this would somehow encourage trafficking, or would it actually have no impact on trafficking?
No, I think it would have a positive impact on trafficking if police were less concerned with their enforcement against consensual sex workers, if they stopped searching for trafficking where it didn't exist, and sex workers had access to labor protections, employment rights, occupational health and safety. Sex workers could act as allies in the fight against trafficking.
So I've got 30 seconds, maybe just a quick question. You talked about learning from others in New Zealand, and we've had some assertions that about what goes on in New Zealand. And what has been your experience or communicating with those involved in New Zealand?
Well, peer-reviewed evidence about the New Zealand model of decriminalization shows that it's been incredibly positive for sex workers there. We hear that there's been an increase in trafficking in New Zealand since decriminalization was enacted. But the problem with that is that one of the problems with New Zealand's model of decriminalization is it didn't decriminalize migrant sex workers. And so any migrant sex worker is captured in statistics as a trafficking victim. And so, of course, it looks like trafficking has increased when that's not the case.
Thank you, Ms. Port. Over to you, Mr. Brock, for 5 minutes.
Thank you, Mr. Chair. And I'd like to sincerely thank all the witnesses for your testimony today, and sincerely thank you for your advocacy in this important area. With time permitting, I'd like to ask Ms. Allison a couple of questions and Mr. Brandt one question. Ms. Allison, over to you. I come from a legal background as well, a former Crown Attorney for the province of Ontario. I would like to hear your thoughts with respect to the recent Ontario Court of Appeal decision in NS, and in particular, your opinion as to whether or not you agree with the court's analysis and conclusions reached.
I do agree with the court's analysis in NS. I think it's an important decision. The key parts of the provisions. I mean, one of the issues that wasn't considered in NS, of course, and is considered in the upcoming Canadian Alliance case, is whether or not the purchasing law under Section 286 is constitutional. But what the Ontario Court of Appeal did was uphold the material benefit provision, the advertising provisions as well. They upheld the purposes, and I know that you've been taken to the purposes of PSEPA, which are key to an establishing a sort of Section 7 argument, if you like, and to find that the three purposes for which the court found where the purposes of PSEPA are constitutional. I think it's a very important decision.
Thank you for that response. Along a similar vein, we know that the Court of Appeal rendered a unanimous decision, so there is no automatic right to appeal to the Supreme Court. If leave were granted, and this is a hypothetical, if leave were granted by the Supreme Court of Canada, do you foresee any constitutional vulnerabilities with any other aspects of Bill C-36?
It's hard to predict what will happen. I mean, obviously, the Supreme Court of Canada, if leave is granted, they will only be considering the three provisions. Obviously, what the court does in making its decision may have an effect on the other ones. The purposes of PSEPA have been upheld as constitutional by the Ontario Court of Appeal. So even though Section 286, the purchasing provision, wasn't available, it still has an influence over that. So the court's decision, the Supreme Court of Canada's decision, NS, will have an effect or will have an overflow effect on the other decisions that are coming forward.
Thank you. Over to you, Mr. Brandt. And I will say your testimony was absolutely gut-wrenching. I know you didn't identify the country that you described, the circumstances as to what you saw, but your description brought me back to my days as being a member of the Brantford Crown Office, being responsible largely for all the internet child exploitation prosecutions for the last 10 years. So it really brought me back to that dark period of my professional career, which really caused me to really reflect on the vulnerabilities of our youth. So quick question with the time that I have. I got a minute and 30 seconds remaining. Bill C-36 made some amendments with respect to the penalties associated with trafficking of adults and trafficking of minors. As it stands right now, there is only a 1-year differential with respect to the minimum penalties for trafficking minors versus trafficking adults. Given your advocacy, given what we've heard today, do you think that adequately denounces this type of heinous crime against our vulnerable members of our community?
Thank you for the question. I would say no. Human trafficking is an outcome of vulnerability. It's progressive in nature. As I mentioned, 75% of people who end up in the commercial sex industry were first exploited as children. And we've seen in testimony through the work with the Alberta Human Trafficking Task Force and in my work over the last 18 years, those initial abuses, those initial victimizations often lead victims into a dangerous spiral that they continue to deal with for the entirety of their lives. And while there can be rehabilitation, there's a lifelong impact from this crime.
20 seconds if you want. Nope. Thank you, Mr. Brock. Now for 5 minutes to Mr. Naqvi.
Thank you very much. I want to go back to Ms. Carrie Porte, please. And I think last time when you were talking to Mr. Garrison, you were describing the experience of New Zealand. And I know Mr. Brand mentioned Sweden as well, and I'm always interested in jurisdictional experience. Ms. Porth, can you walk us through what's contained in the legislation or in the law in New Zealand, and how does that differ from what we have in Canada that we're studying at this moment?
Sure. So in New Zealand, they removed all of the criminal penalties associated with adult sex work. And the sex industry is still regulated by their public health. And public health is a federal department in New Zealand, so it has a bit of a different legislative model than we have in Canada. Sex workers can work independently for themselves, or they can choose to work in sex-based businesses such as brothels. There are occupational health and safety regulations that they abide by, and they have access to employment and labor law. In one situation, a sex worker who was being sexually harassed at a brothel that she worked at by someone else who worked there won a large award because she's sued for that. And so they have far more rights, and they also feel more free to call the police if they need to, if they're in trouble.
And how long has that legislation existed in New Zealand? Or that
They
regime?
decriminalized in 2003.
And so what's been experienced? What's the research has demonstrated in terms of the impact of decriminalization of sex work in New Zealand?
So there's been very positive outcomes for sex workers. They report feeling safer in their work, having more control over their work and their work environments, more able to insist on condom use with clients, and more positive outcomes like that.
So is it your recommendation that Canada follow a similar model?
Yeah, I mean, Canada's model would have to be a bit different because of the way they regulate the sex industry in New Zealand is more of a federal model than it is. Ours would have to be a provincial or municipal model. But decriminalization certainly doesn't mean a free-for-all, and it certainly wouldn't mean an increase in trafficking. There would still be regulations on things like where brothels can be located or what kind of signage is appropriate. There would have to be changes to employment insurance so that sex workers have access to that, changes to labor laws so that sex workers who are working or experience labor has to deal with that. None of these things are available to them now.
Go back to asking you about the conflation between human trafficking and sex work, and we've often has heard in this committee, I would say sometimes using those terms interchangeably, sometimes expressing that one is the same as the other. You started your presentation with that point. Can you explain to us, in your view, what are the differences between the two, number one, and number two, if one to follow a model like New Zealand, how does one create checks and balances so that we don't end up promoting human trafficking in any way?
Thank you for the question. Basically, the difference between sex work and trafficking is that one implies consent and the other does not. Sex workers go to a great deal of care in negotiating with clients the terms of the transaction to reach consent. They negotiate over things like where they feel safe being taken, what acts they're willing to perform. They negotiate condom use and other safer sex practices. Human trafficking victims do not have the option to negotiate at all. that is all done for them, and they are forced into the circumstances they're forced into. So it's quite different between sex work and trafficking. And
Thank you, Ms. Port.
basically, okay.
Yep, sorry. Next, we'll go for a quick 2.5 minute rounds for Mr. Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair.
So if we want to apply the New Zealand method here in Canada, we'd need to tweak it somewhat. Could you please talk to me a tad more about those tweaks that would need to be made? And if we were to move forward with New Zealand's decriminalisation model, how should we tweak it and what should we be careful of in that during that process of doing so?
Well, I think one of the most important things is the ability of migrant workers to be able to work in the sex industry. At present in Canada, any migrant is prohibited from working in the sex industry. And this leaves them in the difficult situation of not being able to contact authorities if something happens to them. And oftentimes, if they do contact the police, CBSA investigation is launched, and they're often detained and deported back to their home country. So that is one thing that we would need to do differently than in New Zealand. Occupational health and safety regulations that govern the sex industry in New Zealand are federal in nature. Ours would be provincial, and so care would have to be taken that there aren't too many differences across the country in how those regulations are introduced, so that we don't have a situation where sex work occurs very differently in each province.
Je m'excuse, je vous remercie.
I'm sorry to cut you off. I only have less than a minute left. I'd like to turn back to Mr. Brandt, if I may. Mr. Brandt, at the end of your testimony, you said we need a cultural change in order to do away with this problem. But we know full well that it's not in Quebec's or Canada's culture to trivialize prostitution or human trafficking. So I'd like you to elaborate on that. What do you believe that we need to change? I understand that education and awareness building are important, but what else? The culture, to my mind, doesn't need to change. I don't think it's part of our culture to promote or be in favour of human trafficking, but could you just elaborate?
Please.
I'm sorry, I didn't hear that. Was that you, Chair?
Yes, just a quick answer, please.
I would say that it is important for us to ensure that everybody who is on this committee and right across Canada to understand what the definition of conflate actually is. I think that it's a term that is thrown around quite a bit, and I think it's important for us to make sure that we're on the same page with what conflate means. It is very important, and the PSEPA is clear that conflating human trafficking and the sex industry should not happen, and I think that being said, they are related. So that shift in culture is to understand the relation between these two issues.
Thank you. Thank you, Mr. Fortin. And over to you, Mr. Garrison, for 2.5 minutes.
Thank you very much, Mr. Chair. I want to go back to Ms. Porth and talk a bit about something that she raised indirectly, and that is that since PSEPA has negative impacts on those involved in sex work, those negative impacts would hit hardest at those who are most marginalized, including Indigenous women. Can you talk a bit more about how PSEPA impacts marginalized sex workers?
Sure. Most of the policing, because marginalized individuals are living their lives in the public space, so they're constantly under police surveillance, and this is a real issue for sex workers who are trying to make a living working on the street. They are targeted for police harassment on a number of different issues, such as they may be earning money in other ways, such as street vending and other activities such as that, which are often criminalized by the police. They are sometimes working in circumstances of homelessness, and so sometimes trading sex for a place to stay or things like that. So, and the law certainly doesn't help with some of the issues that marginalized people have to face on a daily basis. But certainly sorry, go ahead.
Well, we're just going to get, I think, one last question here, and that would be, how does the existing law make it more difficult for sex workers to work together to make sex work safer?
Sure. Well, we know that some sex workers act as third parties to other sex workers, so they may help them with advertising. They might rent a place together to work together for safety. But these sorts of situations can make them vulnerable to material benefit and advertising laws and other laws under PSEPA. And so it's much safer for sex workers. Bedford recognized that it's much safer for sex workers to work indoors and to work together. But many of the sort of activities that would facilitate that are criminalized under PSEPA.
And thank you to all the witnesses in the first round. I want to thank you, your commitment to this this cause and to making specifically the lives of women safer, despite your differences in opinion, is much appreciated. I'm going to suspend very quickly for a minute while the clerk tests the next round of witnesses for their sound check. So just a quick 1 minute suspension. Aboriginal Legal Services Society, Christia Big Canoe for the Legal Advocacy Director. So for 5 minutes, thank you.
Good afternoon, and thank you for inviting me to present to the committee. My name is Krista Bigcanoe. I'm the Legal Advocacy Director of Aboriginal Legal Services, and it is our position that the Protection of Communities and Exploited Persons Act is an end-demand legislation that is not effective. It is not creating positive change, and it increases harm and opportunity of violence against sex workers. Given my limited time, I am going to point to the Pivot Legal Society's Evaluating Canada's Sex Work Laws, the case for repeal, as a good document that this committee is encouraged to read, review, and seriously contemplate. Stigma perpetuates conditions that have allowed predators to murder, rape, abuse sex workers with impunity. Police fail to investigate and prosecute these crimes when they involve Indigenous women, girls, and two-spirited LGBTQIA+ community members that are assumed to be sex workers. The national inquiry into missing and murdered Indigenous women and girls heard this horrific narrative time and time again. Negative stereotypes about sex workers continue to have adverse impacts on the way Indigenous women are portrayed, seen, and treated. An example of this was apparent in the R. Barton case, where Cindy Gladue was reduced to multiple references in court as a Native prostitute, Native girl, and sex worker. Disappeared and murdered Indigenous women are often assumed to be sex workers or reported in the media as being a sex worker. This belief, although erroneous on many occasions, results in less attention paid when Indigenous women go missing. Laws prohibiting the exchange of sex for compensation between consenting adults is not the way to end violence against Indigenous women or to address inequality and systemic poverty. The pervasiveness of these stereotypes and racism is so ingrained that the Supreme Court in Barton in 2019 had to instruct that our criminal justice system and all participants within it should take reasonable steps to address systemic biases, prejudice, and stereotypes against Indigenous persons, in particular Indigenous women and sex workers, head on. Turning a blind eye to these biases, prejudice, and stereotypes is not an answer. Accordingly, as an additional safeguard going forward in sexual assault cases where the complainant is Indigenous woman or girl, trial judges would be well advised to provide an express instruction aimed at countering prejudice against Indigenous women and girls. Sexual exploitation of women, Indigenous women, girls, and two-spirited community members occurs well before they decide to engage in sex work. Indigenous children who are apprehended into child protection services at alarming rates in this country often experience sexual exploitation. Addressing issues of poverty and inequity and decolonizing approaches to child welfare and institutions is the leading way to reduce sexual exploitation that Indigenous children in this country experience. The acute mass incarceration of Indigenous women in Canada's Correctional Institute also demonstrates the high criminalization of Indigenous women. Indigenous women now count for 42% of the woman inmate population in Canada. Laws that further perpetuate stereotypes and distinguish groups, such as sex workers, are harmful, and over-criminalized populations are the ones that face the most scrutiny from authorities, even when it's not warranted. The ban on purchasing sex directly impacts sex workers' safety, Indigenous sex workers' safety, engaging the rights of liberty, life, and security of the person under Section 7 of the Charter, as well as Section 15, the guarantee of equality under the law. The court in Barton also reminded us an important thing, and that is that our criminal justice system holds out a promise to all Canadians. Everyone is equally entitled to the law's full protection and to be treated with dignity, humanity, and respect. Ms. Gladue was no exception. She was a mother, a daughter, a friend, and a member of her community. Her life mattered. She was valued. She was important. She was loved. Her status as an Indigenous woman who performed sex work did not change any of that in the slightest. But as the reasons in Barton's decision shows, the criminal justice system did not deliver on its promise to afford her the law's full protection, and as a result, it let her down. And the court said, indeed, it let us all down. We call on the repeal of PSEPA, is unconstitutional and actively prevents people who sell or trade sexual services from enjoying their fundamental charter rights. Like Pivot, Aboriginal Legal Service was an intervener in the Bedford case before the Supreme Court of Canada. We intervened mainly because of the life and liberty risk the criminal code provisions were creating for Indigenous sex workers. In July 2014, we also made submissions to this committee on Bill C-36. At the time, we objected to the passing of Bill C-36 because of the acute Indigenous overrepresentation in the criminal justice and penal systems. The situation has only gotten worse in respect of those two issues.
Thank you, Ms.
The overall impact, the bill.
I'm going to have to interrupt you, but hopefully you'll be able to answer in the questions coming forward. I'm going to ask, just for the witnesses and those that are not familiar, I have cue cards, so just watch for them. I give you a 30-second warning and then the timeout warning at the end. Our next witness is Ms. Franklin of Courage for Freedom for 5 minutes.
Thank you, Chair. Oh, this is a very difficult day. I'm Kelly Talon Franklin with Courage for Freedom as CAED and Chair of Committees for Canadian and International ECOSOC Organizations for Business and Professional Women. As a survivor of sex trade, I share current experiences with over the 400.
Ms. Franklin, can you put your boom of your mic a little bit lower?
Oh, sorry.
Yep, perfect. Thank you.
With over 427 minor age women and girls, personally and professionally supported, their perspectives I am sharing with information that also has additional information from traffickers, Johns, different areas of sex industry, law enforcement, frontline support workers, friends, families, includes all oriented communities, Black, ethnic, language, religious faith, and all socio-demographics. I do not speak to repeal C-36 PSEPA as it's still in the best interest of Canada as a whole, and ask instead that the committee review of sections and amendments. Also to review of witness testimony briefs and documents against CEDAW concerning difficulty and responsibility of us as a UN-sanctioned nation and as a founding member of individual versus collective and societal rights and responsibility. I would also ask you note the UN's neutrality in view of 4 choices: Nordic model, decriminalization, partial decriminalization, and legalization. My priorities would also say that under decriminalization, that they have been placed as Indigenous women at further risk of harm, violence, and even murder without increased safety or liberties. In Germany, the studies of 80% of their population report that the law does not work. In 2017, all parties there agreed the laws were a failure. In Costa Rica, sex trade women's suffrage, under their legalization, lowered their standard of living to less than $2 an hour, opened doors to international criminals, and placed them as the now #1 Central Latin America country for sex tourism with increased child exploitation, and lowered their tier status at the UN. Canada has a tarnished record, as human trafficking is the 2nd highest national grossing crime. But in our quest for a ranking globally, may we not just seek to legalize all aspects to influence our status, but base everything we do on safety and security, addressing root causes and not governmental controls. In the highest per capita community in Canada, officers I work with have asked me to share the information that they believe repealing will result in more bridges to international organized crime and heightened victimization. Project Maple Leaf, that we founded, saw a large number in sex trade and prostitution have not been charged under these current laws, but the procurers and benefactors from the sale of others as managers in that 5% agency privileged advanced have exemplified personal gain under the guise of helpful support of the oppressed and marginalized. Hard and gray data used actually enabled under the law the discovery of victim survivors in sex trade who were protected regardless of charges laid, plea deals, or prosecution. I agree inconsistent policing does pose an issue, but we also understand that when we bring these issues to the surface, we are going to see a retribution of actions in crime. A sex industry female friend said openly, I am not afraid to say that without PASIPA, myself and others in sex industry would have been arrested and without options. And those that aim to repeal these laws do not speak for me. Repeal will make it even easier for them to buy and sell children, marginalized and oppressed women and youth than it currently is. An 18-year-old who is fighting out of sex trade trauma has been told in a women's and girls shelter that she's not woke and is being gaslit by posters, that her body is her choice and sex work is real work. Last week, she was told that she should do some stripping or rub and tugs as harm reduction to pay for a baby stroller. Statistics show the likelihood of rape both as an escort or in street trade. Murder rates are higher whether it's legalized or not. 95% are still underrepresented by agency. It means that there's no equity in privilege, race, or economy that could be presented to you today, and that third-party profiteers draw on the criminal element. So how can we possibly weigh the effectiveness when some of our measurements activities were not even enabled given the COVID situation? Today, I'm not a conflationist and I'm not wanting to remain polarized, but I demand consideration of sex trade, sex industry, human trafficking, sex trafficking, labor trafficking, violence against women and girls, domestic violence, murdered and missing Indigenous women, sexual exploitation. And as a witness already stated, the consideration of youth sex workers. Yes, consider them, but please consider them as child rape victims and request more report consideration from the Canadian Centre for Child Protection, the National Centre for Missing and Exploited Children, as representatives of also visual, written, and audio sex trade to actually and adequately represent everything, including the previous misrepresented data about jails, probation, and parole. Honorable Chair, what will be the report implications of our time in history? What will be the choices and the rights? You know, if we did not have the means to discover...
I'm going to have to end you right there, but hopefully you'll be able to extract some of it during your questions. I'm going to ask Madam Clerk if Swan Vancouver Society is on. No. I believe the third witness is having difficulty, so we'll bring in a round of questions, beginning with Mr. Brock for 6 minutes.
Thank you, Mr. Chair, and thank you, ladies, for your testimony today and your advocacy in this important area. It's going to help us formulate our studies. So questions firstly to Ms. Big Canoe. I know, Ms. Big Canoe, you did not have an opportunity because of the time constraints to finish your narrative. So I'm just wondering, were you planning on opining or providing any input with respect to the intersection of Indigenous women and girls and human trafficking? Was that part of your narrative?
Yes, it would be part of my narrative in relation to two things: the recommendations that I would make and just a reference in terms of the recommendations we're supporting. So I, much like your formal set of panelists, talk about the conflation between human trafficking and sex work and the need for clear definitions and understanding, but also that there's a couple of things that we need to be aware of when we look at something like the National Inquiries Report and we see the harm and levels done. So in my submissions and speaking notes, if I do not get the opportunity to get to them, there are 6 recommendations that derive from the Pivot Report and 3 from the National Inquiry.
All right, so I'm going to get into some specifics now, Ms. Big Canoe. My former career was as a Crown Attorney for the jurisdiction of Brantford Brant. That I'm sure you're familiar with includes the largest Indigenous reserve in Canada, the Six Nations of the Grand River, as well as Mississaugas of the Credit. Unknown to me, I should have known this, but unknown to me during the past election, it came to my attention by speaking to some of the elders and law enforcement on the Six Nations that the Six Nations leads the country in terms of the percentages of Indigenous women and girls who are victims of human trafficking. I don't know if you were aware of that particular statistic, and I'd like to ask you specifically if you could perhaps provide some explanation as to what is actually going on in that part of my riding.
Certainly, and that question was directed to me, right?
It was.
Yeah. So there is an awareness of the amount of sexual exploitation geographically, but if we're being fair and honest, we actually don't know those numbers with 100% certainty because the pervasive issues around the enforcement of Canada's current criminal code, even prior to PRECEPA's actual trafficking provisions, were not being enforced largely. So a lot of trafficking, as the National Inquiry heard, is quite frankly underground. And the numbers should be shocking of Indigenous women that are trafficked interjurisdictionally, like within a province, through other provinces and across international borders. So I have heard the number is large. The Six Nations is also one of the largest reserves in the country. So if you're looking only at a First Nation reserve, they have over 17,000 members and 10,000 of them reside in a fairly urban context. So it's not actually surprising when you look at it from a per capita basis that might be a truth. And so what's happening in your neck of the woods, I can't directly respond to what the issues are. But it doesn't surprise me that would be a community that puts forward what's happening. So trafficking does happen. And I want to be clear, ALS is not, we're not pro-trafficking. We are not saying that there shouldn't be laws in place and that there shouldn't be enforcement of laws that address trafficking. What we're suggesting is the conflation between trafficking and sex work and not having distinguishable or clear definitions of some of the words within the act itself is problematic and causes life and liberty issues for those that are engaging in sex work.
Okay. Thank you for that. Now, part of your narrative was to talk about the over-incarceration rates of Indigenous offenders, particularly in this area. When you testified before committee when Bill C-36 was being debated, you objected to the bill because of the acute Aboriginal overrepresentation in the criminal justice and penal systems and the overall impact this bill will have on a number of Aboriginal sex workers, their families, and communities. What has been the impact, in your opinion, of Bill C-36 on the overrepresentation of Indigenous people in the criminal justice system and on Indigenous sex workers, their families, and communities?
Certainly. So if we're looking just at it as a statistical game, then you're going to see there's only actually been an increase since I made my submissions in 2014 of Indigenous, particularly women and female youth within our penal and criminal justice systems. The number of those that are tied to offenses that are relate to like sex related has decreased since post Bedford because there's not as many charges, but then there's connections within the community. So some of the provisions in PRECEPA that rely on sort of the livelihood or the potential of benefiting from livelihood are adversely impacting larger communities and broad communities. So the criminalization, so we have to contextualize this and couch this really quickly in the fact that Indigenous people are over-policed or under-policed, depending on the circumstance, but often over-policed or over-criminalized simply for being Indigenous. And so they have more scrutiny, they're seen more often, and the police are following up with or dealing with those communities more regularly.
Thank you.
So I don't think you're going to extract the statistic you're hoping for directly, but if we're looking just at a numbers game, we're only continuing to over-incarcerate and mass incarcerate Indigenous people, including sex workers and people who have been sexually exploited by no fault of their own.
Thank you, Mr. Brock. Now over to you, Ms. Briard. Oh, sorry, Ms. Diab. My bad. My apologies.
Thank you very much, Mr. Chair, and welcome to our witnesses here this afternoon. Madame Krista Big Canoe, I've got a couple of follow-ups, if you don't mind. A couple of things you've said I would like to get some clarifications, but also a little bit more on what you were referring to, I get, and one of the questions that I would have is what would be the benefits of decriminalizing versus legalizing sex trade, in your opinion, and how would that impact the the Indigenous community that you represent, but also you talked about, you had 6 recommendations and 3 that were in the report. I'd like to hear those. And lastly, I'm just going to put my questions. And lastly, what definitions in the Act would you recommend be amended, and how would you define them?
Certainly. Let me start with the recommendations first. Go to your first question, and I can undertake to pinpoint those in a follow-up note to the clerk if I don't get to address them today. So I would point to 6 points in Pivot's evaluating Canada's sex work laws and what we need to do. So the first one is repealing, which seems pretty straightforward. It would also be to use existing laws to persecute perpetrators of violence. No one is saying that violence is acceptable or that sexual exploitation is acceptable, but within the criminal code, we already have provisions. We would add that law reform should consider using appropriate language and not characterizing acts of sexual violence of minors as interfering. So for example, the National Inquiry also made recommendations about the use of language. When we're talking about children, we shouldn't be talking about invitations for sexual touching. Kids cannot consent to sex. And so if there is work to be done, it is in relation to existing legislation and crimes and not an additional suite. And so that I will, again, just refer to my notes because I do want to have a moment to focus on some of the findings from the National Inquiry into Missing and Murdered Indigenous Women and Girls. I did not say this in my introduction, but I was actually co-lead counsel, so was responsible for putting the evidentiary record before the commissioners. And so I have quite fluency with this. And the calls to justice that are really important include 4.3, which calls upon all governments to support programs and services for Indigenous women, girls, and 2S LGBTQ+ people in sex industry to promote their safety and security. And they must be designed and delivered in partnership with people who have the lived experience in the sex industry. And they called for stable long-term funding of these programs and services. And whenever you hear any of your witnesses talk about exiting our opportunities, the solution always comes from the community that is much stronger than forcing people into exiting strategies through police or authority use. Also, call to justice 5.3, asking the federal government to review and reform law about sexualized violence and intimate partner violence. Again, it's about looking at the existing laws and strengthening them. And finally, 12.14, which called upon all child welfare agencies, and you're like wondering what's the connection here, but quite frankly, Indigenous people in particular are exploited sexually more often in youth than general populations. So when they call for more rigorous requirements for safety, harm prevention, and needs-based services, as well as within foster situations to prevent the recruitment of children in care into the sex industry. The National Inquiry also insisted that governments provide appropriate care services over the long term for children who have been exploited or trafficked while in care. So, Indigenous people have this history in Canada, this colonial legacy where we took children, we put them into schools where they were highly sexually exploited. It's been a long-standing history, and sometimes when we say things like, we can't believe this happens in our country, I sometimes exclaim, I can't believe we're surprised it does. That's been the legacy towards Indigenous people in this country. And so, just to be clear, the two views don't have to be mutually exclusive. There are ways to tighten the law to protect those that are treated most vulnerably in the system while still upholding and protecting the rights of those that are engaged in sex work of their own autonomy in a safe way. And we see that in other jurisdictions. I think I'm going to have to probably defer, and you might run out of time. I can pinpoint. There is some terminology. The Pivots one document actually explains quite well in law a couple of the terms that aren't explained well. We more recently have had case law. There was ANWR, which was an Ontario Court of Appeal. Now we have a new Ontario Court of Appeal, that has helped explain things. But there are some loose terms where there's not tight enough definition to just neutrally even work well, whether you're on either side of let's get rid of the law or let's enhance the law. So I would undertake to follow up a note to the clerk and further to my submissions on pointing out a couple of these terms.
Perfect. 1 minute. Okay, thank you, Mr. Chair. Well, we talk a lot about conflation in this committee, particularly in relation to this act. Can you talk to me a little bit about how can you help us, or how can you help in trying to figure out how to distinguish the two, even though there are linkages, but they're obviously separate. Tell me your view on that.
Certainly. And it's a position I took when I talked to the committee in 2014, was we need to not conflate. So using the word conflate to understand there may be connections, there may be pathways between sex work and human trafficking, but you can't just assume that if someone is autonomously working in sex industry that they have been trafficked there. There's different truths for different people with the lived experience. And so I'm not going to try to assume that anyone who has had one experience negates another, right? So there is that difference. The big thing too to keep in mind is it's very common for people to sort of look into those stereotypes that I was talking about in my introductions and make assumptions. And so when we see, and this is the stigma that attaches to sex workers, right? Like are seen in society as either being less than or not worthy victims because they've engaged in something that we might morally think's wrong. But we immediately, when we look at that stigma, we want to extend the stigma of sex work to something like, human trafficking, which we see in society as like the worst thing, to take one human being and do that to another. So it's important to understand the definitions.
Thank you, Ms. Bigcanoe. Thank you, Ms. Diab. Over to you, Mr. Fortin, for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson, and thank you to the witnesses, Ms. Bigcanoe and Ms. Franklin, for being here this evening. Your testimony is important. These are worrying issues, and it's invaluable to have a vision from within, from folks out on the field. Now, I'll start with Ms. Franklin. I have a question for you. I understand that you give talks and conferences that deal with awareness raising about human trafficking. Now, prior to this panel, there were witnesses, and I'm asking myself the question here, there are penalties under the criminal code for those who are charged with human trafficking. And it's my understanding that there are other penalties under other legislation, including the one that we're looking at here today. This is a serious issue. Is there anything else that can be done aside from just imposing penalties? To my mind, it's unacceptable that a man or a woman, or any individual for that matter, could even consider buying a child. It makes no sense. And the witness said there needs to be a cultural shift. I have trouble fathoming that this is part and parcel of our culture. Of course, something needs to change, but I can't believe that this is in Canada's and Quebec's culture to buy human beings for one's own pleasure. Perhaps I'm naive, but I just can't get a handle on that. Now, I'd like your opinion. When you talk about awareness building about human trafficking, and there was a witness that talked about a cultural shift and the need for one, I'm having trouble with all of this. Your opinion, please. How do we put an end to this behaviour, aside from just threatening people that they'll go to prison? And what else can we do to fundamentally change this behaviour?
There are so many answers to that question. I don't think time is going to allow us, but I am finalizing a brief that I will be submitting post-presentation to committee for your review. The first thing I want to answer is by saying that with PACIPA, we have had a means to discover acts perpetrated against oppressed persons, against minors on the short times on the books. And one of the things we need to consider is that in those 427 victim survivors that have been minor age, that I've had the privilege to support and journey along with their families and their communities, regardless of whether charges were laid. And that's the gray data that we don't have on this issue, that the majority of them didn't have agency at that point and didn't understand that it wasn't a decision they made to involve themselves in sex trade. Most of them, it took years of care with trauma and with supports and ongoing. I'm going to be 60 this year. I remember in the early 90s when Kelly Mombercat was murdered as a 14-year-old, and the paper stated that she was a problematic child in the system and she was a child prostitute. We've come a long way from that. We don't need that kind of media reporting. However, that most people that have experienced human trafficking in sex trade do not know that there was a differentiation because of industry. And so teaching those in all industries, working with those that are in sex trade to understand what's happening and getting that information out there and supporting their rights for safety, regardless of what we think about other things. We're all human beings. We can talk about this like they're the 427 case files that I've worked on since 2013, or we can talk about it like they're persons. I have a 12-year-old girl who did not know she was escorting. She did not understand what was happening. And by the time she was age 15 and had allowed a sex buyer to insert a sponge for her to perform, was suffering from sepsis and infections. She had no clue about what had happened to her. And yes, she was sex trafficked, but it happened within sex industry. So we have to understand those intersectional points and how it puts more oppression forward. I had the opportunity to work with the Anishinaabe community as a welcome guest in Manitoulin Island, the largest unceded territory in Canada. And to see what is happening and what they are saying, I was made aware that there is no word for prostitution in the Indigenous culture, that that's been a colonized thinking that's infiltrated their communities and taken a foothold. Regardless of what we believe about all of this, I'm not talking about morality. I'm talking about having an understanding about a sex buyer knowing that somebody is 12 years old. How do we differentiate? How are we going to differentiate? How are we going to identify if we don't have acts against perpetrators to do the investigations appropriately? How are we going to put this into our universities as a course to become us in sex industry? Is it going to be in our high school as a course that you can take? Is it going to be part of the middle school guidance counselors, conversations with our children preparing for high school? And how about that kindergarten person in a little sharing circle about their vision to grow up as a professional? Is it going to include saying that they want to be in sex industry? We need to understand that we have a bigger responsibility than just individual rights in this conversation. So I implore you to do your homework and that prevention does work. I trained over 5,000 professionals last year. I didn't endorse arrests or witnesses. I talked about the trauma that is in both sectors of this conversation, that we have to be presenting solutions.
Thank you, Ms. Franklin, and thank you, Mr. Fortin. Mr. Garrison, over to you for 6 minutes.
Thank you very much, Mr. Chair. And I'd like to turn the topic back to what we're actually studying here, which is the PSEPA law and not the trafficking laws or laws against child sex, which are obviously abhorrent to all members of the committee. So I want to go back to Ms. Big Canoe, and I know it's kind of a frustrating format, and Ms. Big Canoe has always had other things she wanted to say, and I think she had 3 more recommendations she wanted to talk about, so I'd like to give her a chance to do that.
Thank you for that opportunity. It is, I understand the need to have the committee. It is because obviously for people who have worked in this area for a number of years in various fronts, it's not a lot of time. I did also want to just refer to, so I had shared with the committee the 3 calls to justice out of the National Inquiry and a couple of them from the Pivot reports. But one of the other ones that was important is recognizing the complex realities of Indigenous people who sell and trade sex. Specifically, the federal government should increase broad-based support, including through funding to Indigenous communities for self-administered education, vocational training, housing programs, income assistance, and health and addiction service. based in Indigenous traditions. In Canada, we have 613 First Nations. In Ontario alone, we have 13 Indigenous languages. So one Indigenous group cannot say what other Indigenous groups' languages include or don't include. And so it's important to recognize the complex reality of Indigenous people in that context of historical legacy and the way that children have been sexually exploited, even by government-sponsored programs, whether it was intentional or not. We also need to invest in supports and low-income sex workers. So you're probably wondering, Ms. Big, I just asked you this question and you're not giving me an answer as it relates to PRESEPA specifically, except that part of the solution is not carving out the specific law that is not going to address the issues that we know exist. So investing in supports for low-income sex workers, whether they want to do the sex work or not, would also be an important thing. Poverty and discrimination is what drives a lot of choices within industries and outside of it. And using criminal laws to deny people their income sources is not the way to actually ensure genuine autonomy. Instead, people experiencing poverty and discrimination and low income sex workers, whether they wish to do other work or not, need access to more substantial income assistance benefits, safe, affordable housing, culturally appropriate and educational opportunities and health services. So those, in a nutshell, it's like we often in law try to craft something that we believe is addressing a quote unquote problem, but sometimes we're actually creating additional problems or barriers for people like life and liberty ones, or accessing the resources they need to choose to exit or to choose to continue within a safe way of exercising their lives. And thank you for that opportunity to allow those recommendations.
Thank you for setting it in a larger context as someone who's been a long-term advocate of a guaranteed basic livable income as a way of addressing some of these problems. I'm glad that you've raised that important point, even though you didn't put that name on it. I guess my last chance here at questions to you would be to give you another opportunity to talk about something that you said at the beginning, which I actually thought was very important, and that is respecting the diversity of what exists among First Nations, but also among people involved in the sex trade, and trying to understand that there's not one size fits all in these programs. And I really appreciate you for bringing that. Maybe you could say some more about how important you think that is.
Well, so Aboriginal Legal Services, as example, have always accepted clients and met them where they're at. And really, in terms of actually trying to find resolutions or good life solutions for any individuals, is to meet them where they're at. And so embracing diversity and understanding people have lived choices as adults, that within law, I think it's worth repeating, the act of selling sex itself has never been unlawful in the country of Canada. Right? And so putting into place or parameters that meet the safety requirements that don't result in things like over-policing or criminalization of Indigenous people, which is already at beyond acute level. I don't even refer to it as over-incarceration anymore. I refer to it as mass incarceration, because we continue to apprehend Indigenous children into child welfare institutes, and we continue to penalize and put Indigenous people into custody. When there's some levels of autonomy, and when people have power to make decisions and people have the ability to do things in a safe way, then we see less loss of life. And we see that. We've seen that in places like New Zealand within their model, where sex workers have better relationships with police officers. Sex workers can actually utilize the law within that country to, put forward their rights. And if we're truly a place that's concerned with human rights, and the National Inquiry set up their entire calls to justice on this parameter, then those human rights have to include those basic things like dignity, life, and liberty.
Thank you, Ms. Bidkenu.
Well, thank you, Mr. Garrison. Now to Mr. Cooper for 5 minutes.
Thank you very much, Mr. Chair. I'm going to direct my questions to Ms. Franklin. Ms. Franklin, I certainly recognize the work that you do on the front lines with victims. At the outset of your testimony, you stated that the legislation should not be repealed, but you alluded to possible amendments. Now, I didn't hear you elaborate upon that. Are there any specific amendments or improvements that you would see to the legislation?
Well, I believe in the course of these hearings, you've heard multiple amendment recommendations, but specifically those that would continue to allow, well, the first is that we would have a better capacity to put into action in every province, in every community, just exactly what the original intention was of this law. We haven't seen that. And as a result, it's really hard to have a measuring stick against it. But I can tell you that what we have seen on the books is that those that are minors, that because of the laws of PACIPA, and I'm going to speak to the comment by the committee member, to you, Chair, that yes, child human trafficking, better known as child rape, does intersect with this issue. And this law, in its consideration, although there's other laws on the books around children, has had marked success in identifying that type of criminal activity. So how can we ensure that whatever we're amending and whatever we're making recommendations for, that it's consistent and it is being actually worked on? When you hear testimonial that there are certain segments or communities that just refuse to lay any charges or do anything, we have to wonder what's the divide. And I don't think policing is solely the solution. I agree with the other witnesses. This is going to take an all hands on deck approach and a multi-level because of a lot of historical legacy that we've seen. I want to speak and say that some of the amendments need to be considering what we're going to do in the areas of protection in the newest trends that we're seeing. And like I said, I'm going to reiterate this again, that out of the 427 victim survivors that I've worked with that started as minors, that they didn't have agency or understand what was happening to them, understand identifying what sex trade was, what escorting was, and doing the training and the prevention piece that needs to be ramped up in all areas has given us opportunity that we get calls from police officers, from community workers, from hospitals, from Homeland Security. We've trailed girls that by choice have stated that they were in sex trade, only to find them carried from Toronto to Vancouver to Washington to Seattle, back to New York, and then sold for $20,000 into Puerto Rico, needing our assistance to exit and redefine what was safe for them. I'm not saying we need to conflate it with sex trafficking, but we have to have the conversation because the majority of those that have disclosed as adults about their child experiences, as we've heard over and over and over again. And so their narrative is important and can't be dismissed. Right. It is valuable to this conversation, as are all.
Thank you, Ms. Franklin. I only have a limited amount of time, but I think that was a very fulsome answer. I want to shift gears a little bit. During your testimony, you cited other jurisdictions with liberalized laws around sex work, Costa Rica, Germany. We've heard repeatedly from other witnesses, just in fact by Ms. Big Canoe, who cited New Zealand, and others have as the gold standard. I was wondering if you might be able to share your thoughts on the New Zealand model.
I actually am a part of an organization that has boots on the ground in New Zealand and a good friend that's a counselor in one of the communities in New Zealand. And they are still not completely satisfied that what they have done is in the best interest, especially not for the immigrant population, although that's important. But there was a comment earlier today in questioning that said, the information is conflated in that community because they don't.
Franklin, I'm going to have to ask you to wrap it up. Hopefully we'll get you in a second.
So my final point on this is that the Maori Indigenous women have said equivocally that it's not working for them.
Thank you. Mr. Anand Sangari for 5 minutes.
Thank you, Mr. Chair, and I'd like to thank the witnesses, and I'd like to acknowledge that I'm speaking to you from the traditional lands of the Algonquin and Anishinaabe people. And I have a very direct question to Ms. Big Canoe. Are there any elements of this legislation that is salvageable? And if so, what are they? And if not, you've suggested that we strengthen other laws. Can you suggest to give us more suggestions? If you don't have it today, you can always also table it at a later point, but suggest what kind of amendments would be required.
Certainly. So to answer the first part of your question, I think you can look at any law and sort of pick and choose which ones may be the most neutral or most valuable. But I think from a fundamental theoretical position, when you say that you want to repeal the whole thing, it's because the process or the framework itself is failing to recognize some of the issues. And the issue, and I go back to Bedford, the issue is people actually die while doing sex work as a result of being pushed into unsafe circumstances. And quite frankly, some of what this act is doing is recreating the same type of circumstances and situations that put those people into harm, right? That they push them back because of the fear of, police or authorities potentially charging who they're selling sex to. And what that looks like is you're seeing some of those same pre-Bedford conditions where people don't have the ability to put into place safety checks. So when I say the position we take as Aboriginal Legal Services is repeal because it needs to be recast. And when I say recast, I'm actually just talking about legislation that already exists. So when you look at our criminal code, so one of the things that my colleague was just talking about was, all of this evidence and information we have since PRECEPA came in. What about all the information we had pre-PRECEPA about what was and what wasn't being done with the human trafficking provisions within the criminal code? And there was this big conversation last time I was before the committee about how difficult it was to enforce that. I'm still trying to understand what provisions within this legislative framework change or increase the ability of authorities to prosecute or to do what they should have been doing, quite frankly. Now that we've put a spotlight to it, now that we have a law, maybe that's where there's increased reporting or increased uptake. But we actually, within our own toolkit of laws, had the ability to prosecute and go after human traffickers. And we didn't do it well. So how do we address that issue?
Given the limited time, can I ask that you're able to table some suggestions with respect to strengthening other criminal code provisions? And just continuing on that, would it be fair to say that this legislation has had a disproportionate negative impact on Indigenous women, particularly those involved in the sex trade?
Yes. So I'll answer the last part first. Yes, it has had a disproportionate impact. And I would suggest, and Swan, unfortunately for technical reasons, hasn't been able to be here, but I would probably guess that they would be talking about the disproportionate impact it has on immigrant sex workers as well, who are already in precarious positions because of fear of being removed from this jurisdiction. And so, yes, there definitely is, but that's as an ongoing issue that predates even the legislation, right? It's what we know about the overrepresentation and over-policing of Indigenous people to start with, and it's all those bad stereotypes piled on top of each other. In terms of the recommendations for particular provisions, I would point you back to the National Inquiry has some specific findings, specifically talking about the need to increase culpability in relation to certain violence towards Indigenous people. And I think I'd have to undertake, I'm sorry, I didn't anticipate that question. I have to undertake, maybe replying in addition to my other part, the clerk, some potential provisions that could work. One of the things we have seen post-National Inquiry is a change under 718(2)E to include as an aggravating factor when it's an Indigenous woman that's harmed. And now think about it, sex workers get harmed if they can't reach out to police or prosecute these issues for fear of reciprocity or the other harms that this legislation is creating. Where do they go? But if they could access that, and they are accessing that, and they are a victim themselves, they should have rights as victims in Canadian law as well. And so one of those changes in law has been to see an increase potentially in sentencing as a aggravating factor if you target and attack an Indigenous woman. So that's a good example of, enhancing law.
Thank you, Ms. Bikinou. Thank you.
And now to Mr. Fortin for a quick 2.5-minute round.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chairman. Thank you very much, Ms. Bikinou. I only have 2 minutes. So right off the bat, I'd like to tell you I have 2 issues I'd like to broach with you. The first of which is this. I understand from your testimony that Bill C-36, which has been in effect since 2014, has not really helped, if I've understood you correctly, and that it's not a Band-Aid solution to come down hard on people in that manner. So could you just confirm, in your opinion, the provisions currently in effect in the criminal code, are they adequate and tailored to address this issue, or do we need to also amend the criminal code? That's my first question. What do we do with the criminal code in respect of human trafficking and prostitution? Second point I'd like to raise with you is consent. You alluded to it earlier. The distinction between prostitution and human trafficking. Earlier, you said we need to not conflate the two. There was a witness in the previous panel said that the main distinction or difference is consent. And I found that quite enlightening as far as distinctions are concerned. What does it mean when you get consent that it's prostitution, and when there is no consent, regardless of the age of the individual, we're dealing in that case with trafficking of humans?
Right. I don't know if I'll have a chance to answer both, but definitely in relation to your second question, consent is in law sort of the turning point, or what helps us distinguish. So if someone is consenting, if they're not coerced, if they're not forced physically, if they're not, drugged, if they're not sort of quote unquote dragged into it, but they're of their own consent choosing to do something, that seems to be a big distinguishing factor. And that there's tons of case law on that. And consent case law also is in relation to like sexual assault, and that there's more definitions around what consent means that way. So if I'm a consenting adult engaging in an activity of my own volition, then I'm consenting. Right? And I'm not being forced into it. So I'm not being trafficked. So the first part of the question, I don't think I get you the full answer in the time you have, but definitely the answer would be there would need to be some amendments to the criminal code. There would need to be some amendments to the criminal code, but I would suggest that it's not PRECEPA. I'd suggest that you have to look at PRECEPA as the not being effective, and it's not clear enough, and that it's causing or creating pre-Bedford circumstances that is resulting in the loss of life, death, and, from an Indigenous person's perspective, during the national inquiry, another 157 Indigenous women went missing or were murdered where there's unresolved cases. So the violence against Indigenous women is not decreasing.
Thank you, Ms. Bikinou, and thank you, Mr. Fortin. And Mr. Garrison, quick 2.5-minute round to conclude.
Thank you very much, Mr. Chair. And I hope, since we have another session scheduled after our March constituent weeks, that we'll endeavor to get SWAN back onto our agenda at the next available meeting. And I see you nodding, so thank you for that assurance. I want to go back to Ms. Bikinou again and what she said at the beginning, because I think we keep wandering away into talking about what we can do about trafficking, which is another set of hearings we might want to have. But this is actually about PSEPA. And one of the things that you very clearly said in your introduction was that PSEPA increases harm. And just as we come to the end of the session, can we go back to that point you made and talk very specifically about the harms you see directly from this law?
Certainly. So the harms I see directly from this law is quite clear in not just to a person that's exercising sex work, but potentially to people that they're enlisting. So where there should be exceptions, for example, even within PSEPA, of people not being charged because they're acting in a supporting capacity, because there's not enough clarity, for example, on some of those parts of the law. So if I'm like, as an example, if I'm a sex worker and I'm hiring a bodyguard, the potential for them to still be charged, investigated, harassed by police. And once it's being investigated and they're harassed by police, it creates a context where that place is not safe. The other thing is, the majority of sex work is now done indoors. We have internet. We rely on the types of communication through internet. But when people are afraid that they're going to be charged or that police will be involved and they will have their own livelihood harmed, what happens is they don't want to consent or go to places that a sex worker has determined is safe for them to deliver that service, right? And so they're pushed again because the market demands. They're pushed into quote unquote dark corners. They're pushed into places where they know enforcement's not going to happen. So, using the Vancouver example, we heard a little bit from your last panel about that. The Vancouver police made a particular decision in talking with downtown East Side and sex workers not to prosecute because they recognized that it pushed them into corners, it pushed them into dark industrial sections. And then that would be like going back to pre-Bedford. That would be like going back to, I'm not just being smart here, but that'd be like going back to the pig farm. That'd be like letting Indigenous women disappear again.
Gosh.
Right? If they're pushed into dark corners, then they have no recourse for safety. So when I talk about harm, that's the harm I'm talking about. There's obviously a whole human scale imbalance, though. There's many harms happening.
Sorry, I'm going to have to wrap it up there. I want to thank all the witnesses and to the committee for doing a great job. We're slightly over in time, so I'm going to conclude and thank you. And anyone who have to have submissions submitted, please submit them to the clerk and we'll have them included in the report. Thank you. The meeting is now adjourned.
Thank you.